Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
That's Jay Stone Gold, Gary 5 Javo Jeff Kiddos, Mvskoke Radio, Mvskoke. We've got our District Court Judge Viger to carve out a bit of his schedule for us. Judge Viger, thank you for coming in. We appreciate you making some time for us.
Sangonlith, thank you very much and appreciate being here.
All right, well, how do we jump into this? First of all, I guess, let's go back to the beginning then, the McGirt decision itself. We won't get into the specific legalities there, but I want to know what you thought when you heard of the decision being made, and how did it strike you and perhaps your colleagues, without getting into anything that we shouldn't, but wow, it just kind of floored the rest of us. And what did you think?
Well, when we were waiting for the decision, we were nervous as to how it would come out. I think that nobody really had an idea whether we'd win or not. The court was obviously very closely decided, and that's why we suspect that it was held over from the Murphy case, the term before, after Scalia had passed away. There came out, and it was just passed to the next term, and we suspected that, and almost certainly was because there's a 4-4 tie. And then Judge Gorsuch had been on the bench, but they appointed a new judge. But Gorsuch did not participate in that Murphy decision, we suspect, recused himself. And so when it came out, we were very excited that Justice Gorsuch had written the opinion. And I'm sure the people have heard bits and pieces of his from that about recognizing that there was a promise made and that great nations keep their promises. So we weren't surprised. Gorsuch is a very conservative judge, socially very conservative. But when he was being appointed to being nominated for the Supreme Court, United States Supreme Court, many national Indian advocacy organizations supported it. Even though they might have been generally not favorable for his social issues. But when Judge Gorsuch was on the 10th Circuit Court of Federal Appeals, and the federal system has 3 levels. It has the trial levels at the district courts. There's a federal district court in Mvskoke, and there's one here in Tulsa, and then they go up on appeal to the 10th Circuit, which is located from here in Oklahoma, it's located in Denver. And when Judge Gorsuch was on the appeals court in Denver, he issued several Indian law decisions which were very favorable, very well understood the tribal perspective, and recognized treaty rights. And so we were hopeful, but even we were surprised when it came out so strongly in favor of treaty rights. That's probably the most strong pro-tribal decisions in many years. So we were very excited about that.
Now, tribes around the nation have registered their support for the outcome of this particular case. Do you think maybe it was like a landmark or a turning point, as you said, in recognition of tribal sovereignty? Did it underline it, so to speak?
It was for that court. Of course, we now have potential for a new Supreme Court justice being appointed that's in the discussions to replace Ruth Bader Ginsburg, who was the justice that just passed away. And so we don't know how that will impact it. but the decision was a very strong statement that recognized treaties and agreements with tribes made in the past continue to be valid today. And that's a very hopeful occurrence. That did not always happen over the past 30, 40 years.
Right, yeah, as long as the grass grows.
Right. And so I think that's why the tribes around the nation, the United States, were so supportive and so excited about this, because although it impacted the reservation of the Mvskoke nation, the way that it did so was to solidly base itself upon the prior agreements with the United States and the tribe, and that is a positive for all Indian nations.
All right, now for our listeners who may not be familiar with the McGirt case and what it essentially decided, can you perhaps capsulize that decision, kind of give us a real small idea of what it was all about?
Yes, and I think that there's two cases which flowed together, because originally it went up as Mr. Murphy's case. And that's the one I mentioned earlier, which there was a tie, we believe, and so it wasn't decided. Mr. McGirt's case, the Murphy case, came out of the federal courts in a process of appeal. The McGirt's case came from the Oklahoma Supreme Court. And they both involved the same issue, fundamental issue of whether or not the reservation existed. They were, and it's very important to remember that the allegations in each instance were very heinous crimes by the defendant, and so we don't want to ever forget that's what led to this. In Mr. Murphy's case, it was whether, and in Mr. McGirt's case, the question is they were citizens of a tribal nation, and the crime occurred within what was the reservation boundaries. The state of Oklahoma and the United States at one point claimed it was the former reservation boundaries, and the nation and Mr. McGirt and Mr. Murphy claimed it was the continuing reservation boundaries. If the reservation continued to exist, if it occurred on what we call fee land, in other words, lands owned by non-Indians, then with a reservation, either only the federal court or the tribal court would have jurisdiction over a tribal citizen for a crime committed. So in other words, there's different types of lands. It gets a little bit technical. But if the tribe owns the land or an individual owns the land and it's held for them because of their status as an Indian, it's what we call Indian country. If the reservation is disestablished, then it's only lands directly held by those two, by a tribe or the Indian. But if a reservation exists, all lands within it are tribal lands for jurisdictional purposes. So, for instance, if without a reservation, I'd have to basically commit a crime on an allotment or the tribal complex to be prosecuted by the feds or by the tribe. If the reservation exists, if I'm here at downtown Okmulgee and or at Walmart or on the highway, if it's within the reservation, then the feds or the tribe prosecutes, not the state. And so that was the basic issue. Whether it continued to exist from those agreements. And did the allotment agreement from 1906, 1898, those agreements back then, did they disestablish the reservation or did it continue to exist?
That's, I guess, primarily the issue we're hearing in today's news, where some inmates who have been convicted of crimes in the past are saying, well, this was illegal, now you have to do it all over. I need to go to a federal court. We're hearing about arrests, even in the last couple of days, where a suspect or someone like that was saying that I'm a tribal citizen and therefore you have no jurisdiction. This is the essence of the issue.
I think that with the number of cross-deputy agreements, in other words, agreements between the tribe and the state and the local authorities and the federal, there's also some federal special commission cards issued. Generally, the law enforcement officers have authority to do an arrest. It's only a question of where it gets prosecuted. So they have to establish whether they're tribal citizens or not and where it occurred and let the attorneys sort it out. And some of those will be in tribal court, some will be in federal court, and of course, if they don't meet the criteria, they would still be in the state court.
Right now, in a roundtable discussion some weeks back, we heard law enforcement and the United States DAs saying that this decision is not a get-out-of-jail card. It is a way of sorting out the legal paths that these cases would have to follow, right?
Yeah, I think that's probably unless you want to go into a full semester law school course, that's probably as good an answer as any.
Okay, well, yeah, I probably wouldn't make that one. Now, how about its impact? Now, we're seeing systems and codes being worked out. They're telling us that law enforcement officers have been trained and to include this segment in their interrogations. That's, I guess, not perfect yet, but it's still being worked out. So what has been the impact now to our own tribal court, district court? Has it swamped your docket? Is it pretty intimidating?
We've had a significant increase in our caseloads over the past 10 weeks. For instance, from first of the year till, say, the week after, the week of McGirt decision, we had about 16 felony cases filed. 16 felony cases. That's not, a case may have more than one charge in them. In other words, if you're accused of beating up somebody and possessing narcotics, it might be one case filed, but there'd be two charges. So we had some 16 felony cases filed in that 7 months. And since then, we've had almost 240 total. Now, as you kind of alluded to, a goodly number of those are cases which occurred prior to the McGirt decision. So they're not all just cases which have happened since then. And so we probably will continue to see a rise in cases for a while, whether it's 3 months or 6 months. But then at some point that will level off and it will slow down a little bit. I mean, it'll be still significantly over what we had prior, but it will be a little bit less than what we are seeing now, at least. But I think that the biggest impact really is that I was trying to think of how you might analogize to it. It's kind of like trying to get ready for a big dinner or feast or whatever else. And so you have to gather up, at this point, you're having to try to gather all the foods, and you have to make sure you got the cooks and you got the utensils and the menu laid out. And that's where we are at this point. We haven't laid the table to start eating yet. And so we've got these cases which are being investigated, which are being sent to our Creek Nation attorney generals, and which are being filed into our court. And so that load at this point is really falling, to be honest, a lot upon my clerks with these new cases rolling in. And I have four very dedicated, hardworking clerks there at the district court right now. And we're going to need some more clerks. We're going to need them very, very quickly. And in fact, we are trying to advertise and get that out. So if people are looking for those positions, contact our employment, training, human resources, and put in applications. We're always looking for that. And so there will be a caseload, but again, those are at the very first stages. So really, as far as criminal matters, what we've had is what we call the initial hearing, where we bring them in, inform them of the charges, make sure they understand they have the right to attorney, and set it for a later date for the next step in the process. And so we haven't got to hearings, we haven't got to trials, we haven't got to motions. We certainly aren't at the jury stage. So that's 3-6 months off. It's like everything else, it's just kind of rolling down. So I think that it's all manageable. It's going to be manageable. We will have to ramp up. We're going to need, and I hopefully will be meeting with our facilities and other people here very quickly. I've been informed, we have been looking at trying to get a new court building for several years. That's in the master plan. I think that what I've been told is that's moving very quickly to the top of the list for the needs for the master plan. Because obviously, if every day now, we have anywhere from 5 to 10 defendants coming into the court for arraignments. That's just for criminals. We also are seeing an increase in protective orders. We have not yet seen the we've seen increases, but not those huge significant increases in the juvenile matters, say deprived and neglected cases, in part because they have reached agreements with the state to continue on, at least temporarily, with some of those cases as we get them transferred over. But that means we're going to have more attorneys representing those individuals. We're going to have more clerks to file the cases. We're going to have more space for hearings. And we're going to have to really be cognizant of safety issues. Right now, obviously, we're there with the Supreme Court and with the National Council. And so, to be honest, one of my really huge concerns is because while all this is going on, we also have to worry about COVID and coronavirus. And at this point, we're having to transport those anywhere from 3 or 4, sometimes just 1 or 2. But in the past couple of days, we've had 8 to 10 defendants transferred from Tulsa County, David L. Moss detention facility, down to Okmulgee to our court for their initial appearance and a reading of rights and assignment to a case later on, and then in our courtroom, and then transferred back up to David L. Moss. And so every day, our light horse is transporting 3 to 10 people in a small enclosed vehicle, and they're in our courtroom. And that makes me very nervous about that with COVID. We are doing things that we got some CARES monies that we're trying to, that we've actually got in the next week or two, we're hoping will increase our video cyber remote capabilities. We're doing a lot of our hearings remotely. We want our people who are in court for cases to check with the clerks, because we really want to keep them out of the court if we can, for their own health purposes and ours. If our attorneys get COVID and disappear, if our clerks have to take quarantine, if the judges have to quarantine, this whole thing can grind to a halt. And of course, we are very concerned about the light horses' safety and issues in those transports. So it's a lot of moving parts all at once. I was thinking that we probably have 6 or 7 number 1 priorities right now. And so we're trying to take care of each of those. But it is exciting. I think it's well within the nation's capabilities. But there is definitely a lot more work for everybody.
Well, let me ask you about that work. A lot more work. With all these factors taken into consideration, and how many cases have you gotten through that system since this decision?
You mean all the way concluded?
Yeah.
We've had, at this point, we haven't had trials on them because as I was told by a law professor my first semester many, many years ago, and this was not in relation to tribal courts or federal courts, anything else, he just said that the wheels of justice grind very slowly, but they grind exceedingly fine. So things move slowly through the court systems. For instance, Mr. Murphy and Mr. McGirt's cases, which were decided in the past year, started in 2005, I think. So you can see that that's the federal system, the state system. But it can take a while. But we've had some people who've pled out, and so those cases have moved forward. I don't know how many have been concluded. We have set quite a few for the next phase here in coming December and January, and we'll see what happens at that point. A lot of cases are reached by plea agreement. In other words, that the defendant decides that they're going to take an offer from the attorney generals, and that it's reached that way. But not all of them. So we will see. And then, of course, that's complicated by, again, as I mentioned, the coronavirus, is that we have concerns about the health and safety of our jury pool. A lot of our jurors are, I won't say elderly, we excuse elderly if they wish, but even if you're in their 50s, health issues, there's concerns. How do you get 6 jurors in a room and socially distanced for a period of time to conclude a trial? And so those are things that we're still working out. And so we had actually pushed our jury term from March till this fall, and we're now pushing that again off. That has happened generally nationwide in all levels of government.
Well, let me jump in there and ask you this, something that popped into my mind was you mentioned the safety precautions. So are we seeing people coming into your courtroom wearing masks and doing the social distance thing? We
absolutely require it. We did that back, we issued that order, I issued an administrative order back in probably about spring break time in March, when it started to appear that this was really ramping up. And we have been very aggressive about it. We make sure that all the defendants have it. If it slips down over their nose, I remind them. We do not want them to get sick. We don't want them to get somebody else sick. We don't want to get sick. And so we know that it is not a cure-all, but if it increases if it helps us 25%, we'll take that. We have also, for instance, in the courtroom and throughout our clerk's office, placed these little air filtration units, the home units, the HEPA filters. Again, maybe it makes 5%, 10% difference. We'll take it. We had got our tribal construction, and we got CARES money, and we put the high efficiency HEPA filters in the HVAC systems. We've increased the intake of outside air, and everybody that comes in the building has to have their temperature taken and answer a series of questions as to their have they been around any coughs, sicknesses, anything like that. So we're doing what we can, but we know it's not perfect. And that's what we are always thinking about.
With this additional responsibilities there, what's it done to the time it might take for a case to appear before you and then your process? Has it slowed you down significantly?
I'm not sure if it's slowed us down significantly yet. I think that we are moving it. We are increasing a lot more cases instead of maybe having 3 or 4 initials and having 1 or 2 large status dockets, disposition dockets per month. We're having those at least once a week. And so we'll have a full afternoon of video and cyber matters. Now, it does take a little bit longer because we are really trying to get people to appear by telephone or by video, and we're using that method because it keeps everybody a little bit distance. There's less contact. We're hopefully keeping it a little bit safer that way. And so there are issues because obviously there are people in rural areas who are not as connected through high-speed internet. That makes some difficulties. We've been pretty fortunate on having people calling in. We've been trying to be understanding of that. And of course, it takes longer to do that when you don't have, say, 15 defendants and attorneys present in the courtroom that you can just call one after another, A, B, C, D. Instead, you have to have them call in onto the Zoom or GoToMeeting or Blue Jeans, whatever the software happens to be. See if they're there, get the connections worked out, see that that's perhaps the wrong one, get somebody else online, find out where they are. So that takes longer that way. And then, of course, we've got more cases, so we're pushing them out a little bit. We're going to have to get all these attorneys worked out and signed up. So it is taking a little bit longer, but at this point, I'm not sure if it's not like 6 months or a year or anything like that at this point. But we will see what happens as we go forward.
Well, I can sympathize with those folks who are having difficulties with teleconferencing. I mean, our own staff does our editorial sessions with Zoom, and that can be real frustrating too. Yes. when you've got the gear. Would something like a satellite station, say in Okima or somewhere else, be of use to you?
That probably something like that would be good. I know that when I've worked for other tribes in the past, and this was long before anything like these epidemics came through, some of the places had substations. And so, for instance, we had talked, and I hadn't heard anything in the past 2 weeks. That's another thing I need to that we're working on. Is there a way that we could have the remote location in Tulsa for these defendants from David L. Moss to appear? We had thought we were all but ready to have a portable computer and Wi-Fi hotspot placed into David L. Moss on a Thursday afternoon, and one of my employees was ready to run it over there momentarily when he got the call that no, we can't do that unless we get a new contract for having an employee to do it. And that has been a month since then. There has been, we were very hopeful and we're very excited about that, and that has just fallen apart. So whether we can find a satellite office, obviously it's, you'd say, well, why not? Don't you use the River Spirit facility or the River Walk? Well, we're not going to endanger the public that way, obviously. And so we need to find a secure facility that's close, that's transportable, or alternatives. Of course, the best thing would be if we could do it directly through the jail facilities itself. And we've been very fortunate. Mvskoke's been very cooperative. We had things working well with Okmulgee, but now that has been pulled out. So, and I think that Creek County is doing the same, but we really need that. And we're looking at what possibilities for having remote locations over at Mvskoke also.
Now, with this decision being made and kind of a system being put together, a protocol, is there a lot of information available, from the court in particular, to begin with? And then since these decisions been made, is there thoughts in mind, a procedure perhaps for public access filing for information?
We have a court software management system that we're using, and that we have been trying to get that up there and going. I think that some of that is accessible now. We have, I think it was about in the past year that we had it set up so that the people can make payments online and filing fees online, I think. So we think that that's going to add a lot, and we've been very exploring those options.
As the timeline progresses, we're going to be looking at a larger caseload, do you think? Or?
Oh, yes. I think that we'll continue to have more filings as we go forward. We had done some very rough projections into the future as to what it meant when McGirt Murphy was first originating from within internal at the district court. And when it first came up, and it continues to be that some of the state officials are still trying to say that this is like a disaster waiting to happen, and they seem to be throwing a lot of roadblocks up. But when we looked at it on the numbers, we thought it was manageable. It was a significant increase, but it was not going to be tens of thousands of cases. In other words, and it's very, very rough estimates from the numbers we could pull. Say if there was 1,000 cases filed in Tulsa and Wagner and Creek County for a particular year for felonies, we know that only 10% of that population is native. So roughly 1,000, so maybe 100 of those particular cases, or maybe it's, whatever it happens to be, right? So it's not thousands and thousands. We suspect it's much more manageable. It's a significant increase.
No tsunami.
No tsunami. It is certainly a lot more than we had before, but it's all manageable. We have some of the I am very privileged to be on the court with Judge Prescott and Judge Leeds. And there's Judge Leeds is the former dean of University of Arkansas Law School. Judge Prescott's done a lot of trials and advocacy. So we're very fortunate. My staff is very good. I think the clerks there are as fine as any clerks of any of the state or federal systems. We do need looking for a couple more bailiffs and probation officers. So if people have a CLEAT certification and they're looking for a new adventure, we would welcome them through human resources. And it's a lot more work. It's very exciting. But I think that as with all the things for the nation, people forget that we have been around for a lot of years. We did this in the 1860s and 70s and 80s, back before statehood. We can do it again if we're given the chance.